Hello.
No,
Huh? Shampa Ghosh.
এটা তো সম্পা ঘোষ।
Yes, Shampa Ghosh is fourth. Shampa Ghosh fourth. Kindly takes up records of my lord five. But I have five.
Kindly keeps all these matters
Five to the five to.
kindly keeps all these Mr.
You are appearing for the commission?
Mr. Bandyopadhyay.
Yes, let him come. It's not possible to.
We have not even received copies.
Let me hear the matter. Yes,
Yes, sir.
yes, place your case, Mr. Sundar.
Now, my lord, your lordship is having. My lordship I delivered a detailed judgment. I'll be relying upon.
Time is too short. It's
No,
not.
this is the copy of the state. We have not even received.
Let us go through.
No instruction.
Let us go through together.
Yesterday it has been served. My lord, kindly takes up volume 1 first.
Yes, yes. This is item number 5. Yes.
WP 20861. Candidates are class 9 and 10 candidates. Next is 11, 12 candidates.
given a copy.
OMR as of today has not been published.
Yes.
Now kindly comes first to the affidavit of the
All are in the tainted list.
allegedly, my lord.
Yes.
That we are challenging. Kindly comes to page 25. This is the, my lord, report which was filed by the commission in the first round of litigation before the honorable division bench. Page 25.
Where is the tainted list?
The
list of tainted
alleged
candidates?
tainted list is in volume 2, 259 to 292. Volume 2 lordship when it takes up 259 to 229. আমার বিলটা বলবি। They have included persons who were not supposed to be there. They have not included persons who were supposed to be. And 28 August, there is no order. These are the list in respect of 9, 10,
on 30th August 2025.
9, 10 and 11.
Now, whether the petitioner was working in class 9, 10 or 11, 12?
9, 10.
9.
In 9, 10.
Now, in terms of the order of the Supreme Court, whether the petitioner was permitted to work till 31st of December?
No.
Till 31st of December, what steps you did take?
No, my lord. That order will not stand in the way. I'll try to substantiate because we had earlier approached
whether you are permitted to work till 31st.
No.
So after you are not permitted to work till 31st December 2025, what step you did take?
So, my lord, 11, 12 candidates had moved from your lordship's order on the last occasion. The honorable division bench was pleased to direct that if the matter, my lord, if the cause of action arises, then they will be having a liberty to move, my lord. Kindly, my lord,
Matter?
They will be having a liberty to challenge the same.
When
if their candidatures are cancelled. But kindly, my lord, kindly comes to lordship is having an idea, my lord. My lord, lordship has dealt with. Kindly comes to page 25. I'll not be very, my lord, I'll be very fast. Kindly comes to page 25. This is the third affidavit which was given by the commission, volume 1. Volume 1. Third affidavit which was given by the commission, which indicated the names of the persons. So therefore, kindly comes to page 28. This is straight away comes to page 28. The categories of rank jump who are also within the expiry panel were 183 numbers in 9-10 and 39 in 11-12. Lordship has seen that. Now, my lord, kindly comes to the affidavit of the CBI, the written page 117. The 117. This is the list of candidates called for 8th phase counseling dated 3rd August 2020. way after the expiry of panel. These persons have not been included in the tainted list. That is the case that I'll make up. Although these were supposed to be included. Now, kindly comes to the written submission of the CBI before the Honorable Supreme Court, page 123.
But the Supreme Court is in session of the matter.
No, it is not. I will.
Yes,
It
I have
is.
seen the
It is from. I have annexed. I have annexed. I'll show.
session of the matter.
I will show
Now,
you
why
from your
at this
lordship's
stage-
order.
Why at this stage court will enter into this issue?
May not. But after seeing this, lordship may kindly see.
Come to page.
I have, my lord, I have seen the order. It arose
August.
out of your lordship's order.
Come
where
to
his
page
lordship-
28 August
28
2025.
August, 20.
Bijoy Vishwas.
Yes, yes. My lord, three things there. I understand
Please
what
come,
is.
please come.
Yes, yes. 252 page.
Learned Senior Counsel appearing as commission that a list of tainted candidates who were selected, whose selection has been set aside by the High Court and confirmed by this court, would be placed
In public domain, that is on the website of
of
such
the
and
West
such
Bengal
within
Central
7 days. We
Inspection
take this
Council.
statement on record. So it's a concession.
Yes, please come to the next order.
Next order.
Next
my lord.
order dated
Yes.
dated 29th of August. Yes, please come.
ঠিক আছে।
Internal page 4, second paragraph. That is in the case of Bijoy Padia,
বিজয় পাড়ি
Vivek Padia.
কত নম্বর কথা বিজয় পাড়িয়া বের কর না আমার কালকে লাগানো আমার বিটটা Page 4. As we have already directed that the list of tainted candidates
Directed list of tainted
which
candidates
order?
should be
Which
placed,
order? Kindly cease.
should be placed in the public
Which order?
domain
Directed
within the period.
by
Directed
28th.
list of tainted candidates should be placed in the public domain within a period of 7 days.
Yes. I am not drawing any.
And
I am
that
not
issue is
saying
still
anything.
pending,
I am not
pending
saying
before
I
the
am not
Honorable
saying.
Supreme Court.
I am
At
my
this
content.
stage, just before commencement of the selection process,
Yes.
court will not enter into
Yes,
court
yes,
will not
Lordship may
conduct
not.
roving inquiry.
Lordship, it is not a roving inquiry.
Yes, yes.
It is not a roving inquiry. Kindly, I'll not. Kindly comes to your lordship's order, man. Kindly comes to the Supreme Court order once, and thereafter your lordship's I'll show.
Yes.
Page 136. I'll be very short. Lordship is having an idea. Kindly page come 136. Kindly comes to the directions which have been quoted in the Supreme Court. Thereafter again quoted in the division bench. 136. Lordship is there in 136 of volume 1.
Yes.
Yes, it is being quoted, my lord, the order of the division bench which has been quoted in the Supreme Court. Kindly comes to 4. Persons who had been appointed outside the panel. Lordship is there. 1, 2, 3, and 3 has not yet been complied with because the 11, 12 candidates, they don't have their OMRs as of today in public domain. They know what were the OMRs recovered. Now kindly see 4. Persons who have been appointed outside the panel after expiry of the panel, and also those who submitted blank OMR sheets but obtained appointment must return all their remuneration and benefits received by them to the state exchequer along with the interest of 12%. So therefore, subsequently, the division bench has interpreted these persons to be the tainted persons. We are not outside the panel. I have we have not submitted blank OMR. OMRs that annexed with the writ petition I can substantiate. And we are obviously not expiry of panel. Because we have been appointed in September 2018, January 2019. Now, Lordship has
just a minute.
Volume 2.
Just a minute.
এখানে যা এইটা দেখাচ্ছি এইটা দেখাচ্ছি নেক্সট ভলিউমে আছে 150 করে দিয়েছে না পরে পরে ভলিউমটা দেখ 159 হ্যাঁ 2 সেকেন্ড ওয়াচ আচ্ছা আচ্ছা এটা same. But Lordship,
Just a minute,
I have annexed. I can, my lord, straight away indicate. Lordship wants your lordship's order.
No,
The order passed by the division bench.
just
It is annexed. Oh, that copy. Yes, yes. Thereafter, I'll be relying on paragraph 30.
just
I could have, my lord, assisted your lordship, my lord,
I
indicate.
require your assistance.
Because I understand lordship has read from another brief. Markings are there. I also feel this difficulty. Same thing when I read again.
This is paragraph 363 of the judgment of
The judgment of the Honorable Justice Devanshu Bosha, Division Bench. Lordship requires the judgment of Justice Devanshu Bosha, Division Bench. Here, the judgment is there. Or if your Lordship is having a marked copy, then Lordship may kindly take it from there.
It is 22nd April 2024.
Yes, yes. Lordship is seeing
Paragraph 360.
Yes. That has been quoted here only because the judgment was very bulky. I have not annexed.
Yes, yes. বলতে পারো।
কলম্বোকে বলতে আমি অপোজ করেছি তার জন্য পাস ওভার হয় ঠিক আছে থ্যাংক ইউ ফর বাফার থাকা ভালো কিশোরদা যখন সবে একটু সিনিয়র হলো আমরা যখন ঢুকছি আমরা
You are relying upon paragraph 4 of subparagraph 4 of page 363
paragraph
of the
360.
judgment dated 22nd April 2024.
Yes, which has
Now
been
it says
held and thereafter
persons who have been
interpreted.
appointed outside the panel
We are not
after expiry of the panel.
We are
and
not
also who submitted
blank
blank
OMRs.
but obtained appointments must return all
Yes.
remunerations and
Yes.
benefits received by them
Yes.
to the state exchequer.
Yes.
But these are the probable, it's not possible to point out and pinpoint all the illegalities.
It has been
These
pointed
are the
out.
probable illegalities based on which honorable division bench gave directions.
Now, division
Now,
bench has
and that is
subsequently clarified.
and that is confined that what is the effect of these three contingencies? The effect of three contingencies is must return all remunerations
Yes.
and benefits received by them.
Yes.
But
Now,
there may be other tainted candidates.
that is
Mr.
why entire
Laili.
panel goes.
There may be other tainted candidates.
Illegalities.
So therefore, at this stage, by roving inquiry, it is
Lordship
not
may not
possible.
do a roving inquiry. That is what I am trying to say. Now, kindly comes to page 159, paragraph 30 of Supreme Court. Lordship is having the Supreme Court judgment, my lord. Paragraph 30 kindly comes. Internal page 32. 30 and 31.
Of 3rd April.
Yes, Supreme Court.
এই আমাকে একটা সাদা কাগজ দাও।
It is easier. That is why, my lord, I am referring to the paragraphs. Proving inquiry will not be required. That is what I'm trying to substantiate. Because it has already been interpreted and it has crystallized.
Yes, which paragraph of
Paragraph
judgment dated
30,
3rd April you are
31.
relying upon?
Paragraph 30, 31. This is to substantiate that persons who were supposed to be included has been excluded. 30, 31. আমি কিন্তু অপোজ করিনি possible.
No, no, no.
Paragraph 30 and 31. 31 kindly come straight away to 31. WBSSC had tried to justify the extension of the term of panel. As noted above, the time period of 1 year specified in Rule 21 of the destruction of the OMR sheets coincides with the time period specified for validity of panel. There is no doubt that counseling process and the appointments made to the post of assistant teachers 9, 10, 11, 12 were made after the expiry of panel. This is illegal and contrary to the rules. Reliance on orders stroke judgments of the High Court in stray cases of rank jumping were highlighted, where the High Court directed to appoint candidates after the expiry of validity of panel would not have been significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment produced and not specifically examples. So therefore, court specifically says that expiry of panel illegal. But my lord, they have included
Just a minute.
Second one.
Yes.
Page 160. Now kindly comes to the ordering part of the Honorable Supreme Court. Lordship has read many times. I will not trouble your Lordship. Only page paragraph 45. Paragraph 45. The last question. Paragraph 45.
Yes, paragraph 41.
Lordship has, so therefore that order is not interfered. I may have shown your Lordship to I thought that I'll be drawing your Lordship's attention to your Lordship's order. Page 209 is your Lordship's order, your Lordship's interpretation. And paragraphs 21, 22, 23, paragraphs 209. It is your Lordship's interpretation. My lord, if your Lordship wants, my lord, I can place it. If your Lordship is of the view that I remember everything, I'll not. 21, page 209
Of your repetition.
of the writ petition, volume 1. Volume 2, so sorry, volume.
Page.
Page 209. Paragraph 21. On bare perusal of the concluding part of the judgment dated 3rd April.
Just a minute. Yes, explicit.
On bare perusal of the concluding part of the judgment dated 3rd April, it is crystal clear that on the finding of egregious illegalities offending Article 14-16 of the Constitution, when the entire selection process is set aside and not resulting in cancellation of the engagement of the two categories of candidates, one category was termed as tainted and the other untainted. While dealing with the appointment of tainted candidates in paragraph 45, so tainted candidates, paragraph 45 means 363 of the judgment dated 3rd April 2025, it was categorically observed by the Honorable Supreme Court that their appointment was result of fraud which amounts to cheating, based on which judgment of the Honorable Division Bench dated such and such was not interfered with so far as the tainted candidates are concerned. At the same time, while dealing with the cases of the untainted candidates, it is observed in paragraph 46 of the judgment dated such and such, the entire selection process was declared null and void due to irregularities with violation of such and such. Therefore, Honorable Supreme Court found it fit to cancel the appointment. Untainted candidates were not required to refund the salaries which they received after appointment, but such relief has not granted to the tainted candidates. Only common feature between the tainted and untainted, which was found by the Honorable Supreme Court, is the appointment of both categories of candidates were required to be declared null and void. Therefore, paragraph 45 and 46 of the judgment, there is no gray area in differentiating tainted and untainted candidates, and same stands fortified if one considers observation in paragraph 29 of the judgment. Thereafter, though argument has been advanced on behalf of such and such, that difference may be Honorable Supreme in tainted, untainted is only to the extent of granting, non-granting benefit of age relaxation. I am not concerned with that. Paragraph 23, it appears to this court that there is substance in the submission made on the petitioners that by no stretch of imagination, on reading paragraph 45, 46, 49, judgment of them can be considered to be tainted or permitted to participate. I also do not have any issue with regard to this. Now kindly comes to the appeal course judgment. The appeal carried by this commission. It starts from paragraph 215, page 215. I will not trouble your lordship with the entire thing. I'll be only praying that your lordship.
250.
215. 215.
250 or 215.
From 236, the finding starts.
Why you are not going to the Supreme Court?
Yes, kindly comes to this division bench.
In terms of the order of the Supreme Court, this
that has been
interpreted. Today court will interfere.
That has been interpreted. That is what I'm trying. Kindly comes to page 200.
And more interesting is this: after publication of list, who were permitted to undergo or who were permitted to work till 31st of December.
There was no publication of list. That is my contention.
You are not permitted.
No, we were not.
You are not permitted. So why you did not make demo at that point of time?
Because at that relevant point of.
And now at the fag end of the just before the initiation of selection process, when a list is published, you are trying to unsettle it.
This is for the first time the list has been published. It was not.
That is in terms of the Supreme Court, and Supreme Court is in session of the matter. Mr. Lahiri, there should be a limit of everything. And you are coming on behalf of tainted candidates, allow us today. And you are not permitted to work till 31st of December 2025.
I understand what is falling from your lordship, my lord.
Enough is enough.
Kindly
so what tainted is concerned, enough is enough.
But we are not tainted. It has been said by division bench. Kindly see the direction of the division bench.
Now you have become senior advocate. You have more cases to do.
No.
Rather than appearing on behalf of tainted.
This is which we have been facing from 2023. Matters were taken up. We were not parties when we.
And what Supreme Court has said.
Kindly.
Just a minute.
May I finish this?
Just a minute. What Supreme Court has said, please come to page. Come to this order dated 29th August 2025.
28 or 29.
29th August 2025. In Vivek Padia's case. Both the writ petitions are pending for consideration.
But Vivek Padia and the other,
both the SLPs are pending for
consideration. These both these matters arise out of your lordship's judgment.
That if any tainted candidate slips through the net and manages to appear for the test, the notice dated 25th August 2025 issued by the Commission stating that the eligibility and ineligibility of the candidates would be examined in the post-examination stage would come to the aid of the Commission.
That is what I'm saying.
What? No.
I will not be getting anything if I participate. Even
Court has
after
said that
getting the appointment letter, my appointment letter can be cancelled.
if any tainted candidate slips through Supreme Court.
Yes.
But with regard to the candidates who have been identified as untainted candidates, there was no
I will show.
there was no observation.
I will,
but in case of tainted, there was a direction for
even if I am a tainted,
further filtration.
Yes, even if I am a tainted, I will not be able to get the appointment, but I will not be able to give the examination. And my lord, persons who have slipped in 183 numbers of persons that I have drawn your lordship's kind attention, they have not been included. They are now going and sitting in the examination after being appointed post expiry of panel.
What is disturbing this court problem is this, that after you are not permitted to work,
I understand.
31st December.
Why you have not come? Why you have not
you
come?
did
But
not raise any demur.
I understand. But my lord, after giving the application, admit cards were given to me. Kindly comes to my lord. Kindly, my lord, may I just finish, my lord? 239 and 236 is the finding. I will not trouble your lordship. Kindly comes to the relevant part, 239 of the judgment passed by the Honorable Division Bench, presided over by the Honorable Justice Shomen Sen, arising out of your lordship's order. 238. 238, the paragraph 363 is quoted. 233, lordship is there. Lordship may not read it. Kindly comes to paragraph 32. Lordship is seen in paragraph 31. Paragraph 363 is quoted in deciding all cases.
Paragraph
31. 280, 238. 31, 363 is quoted. I am not placing. Kindly sees. Subparagraph 4 is also there. Lordship has gone through minutely. Now paragraph 32. Paragraph 236(4) has classified 3 categories
paragraph
of
32.
candidates. Yes, 31 is the quoting, quote unquote. Paragraph 363 has classified 3 categories of candidates who can be described as tainted candidates.
Then paragraph 363(4) was considered.
Now,
yes.
Persons who have been tainted outside the panel, we are not. Persons tainted after the expiry of the panel, who are working and who will be participating.
That the probable tainted.
My humble submission is it is not the probable, my lord. This interpretation has been made by the division bench, not challenged, binding upon them.
Can just 1 minute I will.
And persons who have submitted blank OMR.
OMR mismatch tainted.
I'll be joining.
I'll
be joining an
because
issue.
OMR mismatch tainted. OMR has been
Blank OMR.
fraudulently has been done.
Blank OMR.
Just hard OMR blank is also tainted. In addition to that, this is also there.
That might be there.
I mean, tainted is about done.
Yes, because these are what court is saying, that paragraph 363, or the main paragraph of judgment dated 22nd April 2024 of the division bench, where it is stated that there are 3 categories of tainted. That is the probable categories, not all categories.
My humble
not all
submission-
categories.
My humble
It is
submission
not
is this is
possible
the interpreted by the
possible
division.
to pinpoint all the categories of
division
tainted.
bench has
Find
pinpointed.
that from the division bench, when the bench presided over by Justice Basa, and also by the Supreme Court, the tainted candidate in one case, it has been given the chart has been given. OMR, these are on the basis of the CBI, right?
Yes.
These are all tainted. Second is beyond the panel which who have been taken. Oh, yes, rank jumping. I was forgotten one. Rank jumping was also.
I am not rank jumping. I have shown the list of rank jumping.
Rank jumping was also tainted. Rank jumping was also tainted.
Persons who had been appointed outside the panel.
What I am saying,
of the panel,
in addition, these are the.
My lord, outside the panel includes rank jumping.
It cannot be.
That is the.
It cannot be said. OMR mismatch is not tainted. Rank OMR is not tainted. But OMR mismatch is
Blank OMR is tainted.
And also submitted blank OMR.
Yes,
Blank
we have
OMR
not
is
blank
was
OMR.
classified as tainted
But
under paragraph 363(4).
yes,
Not
not
blank
that is.
OMR.
But here, what you want to say that we are not
Mr. Lahiri wants to say that there are only 3 categories of tainted candidates.
No.
Under paragraph 363(4). What are those categories? Candidates appointed beyond the panel, candidates appointed outside the panel, and candidates who
Expired.
submitted blank OMR.
But then in that case, OMR mismatch is not.
Blank OMR and OMR mismatch
But
is
OMR,
totally different.
no, OMR mismatch
OMR
is not.
mismatch is a 1 marks also.
OMR
I'll show.
mismatch is the greatest tainted candidates. Everything has been fallen because of the OMR mismatch.
Now, my lord, I'll show
OMR
your
mismatch
lordship.
is the and
But may I complete, my lord? Our senior friend will get.
Mr. Light, this is not nothing to be talked much. We are also facing the courts also. Let me be very clear. We are treating them as a tainted. We are treating them as a
But
tainted.
persons who are supposed to be treated as tainted is not being treated as
that
tainted.
You challenge that.
I have challenged
you
here,
make them
here
party.
and now, here
You
and now.
make them party and come back, then we will see
In
to
the
that.
in
Without-
neither of the
Well, anyway,
litigations.
now, my lord,
Lordship is-
yesterday
lordship
also,
is-
my lord, yesterday, although I was not there, I have received the instructions from my advocate on record. Yesterday also, one of the matter was taken up, and other petitions have been dismissed. One there we have said, they have shown. It will be very clear to your lordship if I say that there are mismatching of the list of the tainted and the CBI start, which we have said the list which has been published by the SSC, that they were all appointed, right? And the difference between that, they are also tainted. We are also cancelling their admit cards also. And we have said also, there may be some, everything is not filtered at 5 lakhs applications are there. It may not, but ultimately, if anyone is there, we'll cancel. And because this is the order of your lordship's order, which has been upheld.
That is
they
what I'm
cannot
saying.
be treated. They cannot be accepted at all.
That is what I'm.
This, even if I miss anywhere, let's assume, if I miss anywhere, that here I'm missing, he has got it.
At the time of verification.
At the time of verification, I will do it.
But that is what I'm saying. If I appear in the examination,
if you appear in the examination, Supreme Court
kindly
will throw
cancel
you back
me. Kindly
in
cancel.
Jamuna.
I will get an opportunity. I want to go to Jamuna. I want to go to, but after appearing in the examinations, not like this. No, if I miss examination, man, I will not be able to appear. 156 has not been accepted.
Yes.
156 has not been accepted.
See, below.
156 has not been accepted.
Table 1.
Let us, yes, see.
Just a minute.
156 of the writ petition.
Supreme Court order. Lordship is taking the Supreme Court order, always paragraph.
3rd April 2025 order.
Yes. 156 minus second volume order.
Paragraph.
Paragraph 25. Page 150.
Just a minute.
First similar, in the written submission filed on behalf of WPSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who are.
Just a minute. Just a minute.
Lordship, kindly see, these are the submissions which have been recorded.
In the written submission filed on behalf of the WPSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who earlier jumped rank, were appointed despite not being in panel. The details are absent 74 rank jump, out of panel but still appointed at 111. Assistant teacher for class 11, 12, 20, out of panel but still appointed 18. Well, this is the 9 and 10, that's the written answer. Then table 2 find the WSC for candidates who are appointed by manipulating the OMR state. Table 2 is as under.
Table 2, assistant teachers plus.
OMR score mismatch for CBI made.
Where you are getting the manipulating this? Yes.
Yes. Who are appointed by manipulating the OMR states.
But these are the submissions.
No.
I'll show. These have not been accepted.
What is tainted?
Kindly see paragraph 28.
Therefore, kindly see and answer 952. Then assistant teacher, candidate were appointed, I will not show. Assistant teacher for class 9, 907. Then in another it is a file on here in this code. It is claimed that on further verification, the following details of the candidates who either jumped rank or were appointed despite not being in the panel came to light. Rank jump 74, loss of particular.
Which table 2?
Next.
Paragraph 26.
Yes. Paragraph 26. 26. Table A, table B.
Yes. Yes.
Therefore, these are tainted. But why the Supreme Court has said all tainted
Kindly reads.
Remove.
Kindly reads on.
Just 1 minute.
Yes.
No,
accent. I understand. I know.
3 minutes. Therefore, these all were terminated. Number 1. Then the Supreme Court will file the applications for all. I mean, both file the applications for group 910. 910 C and SC. Supreme Court has said, we are allowing you to keep this for the timing. Number 1, up to 31st December, you have to complete the examination. Number 2, no tainted candidates should be allowed. First, he has not challenged the termination. Second, he has not.
There is no termination as such, as of today.
Cancellation of appointment.
There is nothing.
By Supreme Court.
Nothing. That is by Supreme Court. Thereafter, it has not been indicated to us. Where is the cause of action? How will I come and say?
Don't come. Don't be excited.
In this matter, don't raise your voice.
Second, my lord. Second is.
He was my leader. He knows everything.
Lordship has pointed out. Already pointed out. You have not been allowed to join. After 31st December. Why did you not?
Where is that order that candidate 17th? This is 17th April.
17th April is page 175. 175. Now, kindly, before going there, kindly come to page, paragraph. No, একটা কিছু না আমি শেষ করব বলেই দিয়েছে শুনুন।
May I read? We are inclined to accept 175.
17th April order.
Page 175.
Yes. The examination and the inter-recruitment process shall be completed by 31st December. Then paragraph 3, the state government and the applicant
shall file the respective evidence by 31st May 2020. Copy of the advertisement for the place recruitment as well as the civil therefore so as to ensure completion of the recruitment process by 31st December 2000. In case the advertisement is not performed by transport are not filed by the court, they will have to go to order to pass the clarify this order cannot be read as a conferring any presence. We are not inclined to accept the prayer in the present
TD.
No.
Oh, but where is the
yes, sir. We are inclined to accept at the top line of the order or of the order first beginning. We are not inclined to accept the prayer made in the present application so far as not found to be tainted subject to the following. And last.
So this is the prayer made by the West Bengal Board of Secondary Education.
Board.
Yes. Permitting them to permitting the untainted to work.
No.
That was accepted.
They filed an application to allow everyone. Board Supreme Court has said no. Kindly come to the last lines.
That is CD.
This order in respect of action not found to be tainted in that student undergoing study.
Which paragraph?
Last part 1. Page 176.
That is in connection with Group C, Group D.
No. After that. What has prompted us to pass this order? In respect of the assistant teachers.
Just it. Place it, which paragraph?
Just come to 176. Lordship, come to 176.
You are on the order date 17th April 2025. Passed on miscellaneous application 709 of 2025.
Yes.
Which paragraph you are relying upon?
Let this page, can you come to next page?
Yes.
176.
There are 1, 2, 3, 4 paragraphs.
After that, we clarify that these orders cannot be read as a confirming any special right or advantage on the advocate teacher in so far as the press recruitment process is concerned. That is untainted. Then we are not inclined to accept the prayer in the present application so far as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in the said group is substantively high. And secondly, what has prompted to us to pass this order in respect of assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of the lack of teachers and the lackness and failure, which have resulted in the order passed by this court.
So that after this observation, we were not permitted. After this observation, you were not permitted. After this observation, you were not permitted to work till 31st
I am not,
which goes to show that you are considered as tainted care.
that is the interpretation. We have not been informed of anything.
Yes.
We have not been informed. This is for the first time it appears that our names have been taken into account. Number and Mr. Bandyopadhyay has shown paragraph 25 kindly comes to paragraph 28 of that Supreme Court. That your Lordship is seeing the Supreme Court from your Lordship's brief, Malad. Your Lordship's brief. Malad, your Lordship is having Supreme Court alada kore. Yes, that one.
Yes, they are only 363 paragraph.
Now, Malad, no, not 360. The Honorable Supreme Court judgment, main judgment.
Yes.
Paragraph 28. Kindly see paragraph 28. Because Mr. Bandyopadhyay has shown, Malad, the submissions, which starts from paragraph 25. Submissions, the charts. Now, in view of the fact that the charts were contradicting and the charts have been subsequently improved and all these things, that is the finding of the Supreme Court. Kindly sees what the Supreme Court holds. Paragraph 27. From that, at this stage, we would like to kindly skips paragraph 28. At internal page 31 of the judgment. I'm sorry, Malad, I'm traveling with Lordship, Malad.
Yes, paragraph 28.
We may have accepted this argument.
Yes.
If WBSSC had the original physical OMR sheets or the mirror copies of the OMR sheets. So the previous arguments are not being accepted. Chart also. However, WBSSC accepts that they do not have the physical OMR sheets as they were destroyed in terms of Rule 21 of the classes such and such, which required retention of OMR sheets for only 1 year. Rule 21 of the such and such, well, it is quoted. Thereafter, admittedly, the OMR sheets who have been applied for non-teachings. Well, I'm skipping that. That relates to non-teaching. Thereafter, paragraph 30. Moreover, given that the recruitment process was ongoing even after 1 year validity period of the panel, there is no justification for destruction of OMR sheets. It is apparent that the time period specified in Rule 21 was coincide with the time period specified for validity of the panel. Further, WBSSC did not maintain the mirror copies of the OMR sheets in their computer records. Thus, the destruction of the physical OMR sheets and the failure to maintain scanned images of the OMR sheets are significant factors which were rightly taken into consideration by the High Court. We concur. Thereafter, paragraph 31 that I have already placed, WBSSC has also tried to justify the extension of the term of the panel as noted above. The term period of 1 year specified in such and such for destruction of OMR sheets coincides. There is no doubt that the counseling process and the appointments made to the post of assistant teachers were made after the expiry of panel. That matter I have indicated to your Lordship what is the list that they have given before the division bench. They have not been put in the tainted list. It is illegal This is illegal and contrary to the rules. Reliance on the orders stroke judgments of the High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after the expiry of validity panel would not have any significance. So therefore, Supreme Court deprecates the persons who have been appointed after expiry of the panel. And the list is there before a lordship. And I can substantiate at least one candidate, and I can substantiate the entire list. None of the names of this list who have been appointed in the 8th round of counseling, which was held on 3rd August 2020, have been included in the tainted list. And we are outside. We have been included.
Yes. Yes, that's all.
Now, my lord, kindly, this list I have shown to
Yes,
you.
yes, Mr. Sen.
And my lord, another point.
Yes.
1%, my lord, another, my lord, item number 4, it's different. Kindly, my lord, takes up item number 4. Item number 4. 7 and 4 is on the same. Kindly gives me 1 minute time. I'll place item number 4 because there the affidavit of the SSC says in the first round of litigation that these persons are not tainted. It says I'll rely upon that one. 19. That is also 4 is also 19. And the only distinction feature between 910 and 1112 is in 910 the OMRs were published. But in 1112, the OMRs were directed to be published by the Honorable Justice Abhijit Gangobadhyay. We moved, my lord, an intra-court appeal that was stayed, and the Honorable Supreme Court directed that only the names will be published, the OMRs. So that 1112 candidate, as of today, do not know what is their OMRs. There is a direction in the Honorable Division Bench presided over Justice Devanshu Basak's judgment to publish the OMRs.
Item number 7 is relating to 910. Basically, points are saying what your lordship is interpreting paragraph 363 of the division bench order. Your lordship's view is that is only illustrative. That is not exhaustive. But I would like to just read paragraph 363 with the Supreme Court judgment to show that that 3 becomes exhaustive because of only the fact that the Supreme Court was of the view that there was no original MR sheet. Also, OMR sheet, there was no original and the originals were destroyed. So therefore it was not, and there were several disputes raised with regard to the scan and the mirror copies.
Yes.
So therefore it cannot be said with certainty that other irregularities concerning the OMR sheet. So therefore, what could be said is that blank OMR sheet. That is something which is conclusive to make it within the category of tainted. But whether the other irregularities relating to the OMR sheet will also fall within the tainted category, for that one has to come to a conclusive conclusion. Yes, this is the copy which is produced in the original, or it is exact copy of the original.
Your whether the petition is working?
No, December 31. That is
not
there.
Working.
Not working.
So what steps you did?
But that I understand. But here, my lord.
No. What you understand? Why steps were not taken?
Yes, well, that is what I wanted to answer. Your lordship.
That others are permitted. Why you are not permitted?
But that I was not part of the Supreme Court.
No, that is not required. You are not part of. When you are not permitted to work till 31st of December, you should have approached the authority for taking steps. That why I am being I am not being permitted to work till 31st.
Because then they will show that this
31st of December 2025.
That the Supreme Court ordered that is going to be cited.
Yes. So therefore, you are being treated as untainted from the after the list was prepared containing names who were permitted to work till 31st December.
Well, this does not categorize or segregate the
It goes
tainted
to
or
show that
untainted.
you are being treated as tainted candidate.
Well, your lordship will kindly
Only those candidates who were treated as only those candidates who were treated as untainted were permitted till 31st of December in terms of the order dated 17th of April.
Well, with the greatest of respect, well, that division, if it was already possible, then the Supreme Court would not
For that, Mr.
would
Sen,
not have cancelled the entire process.
There was no requirement to wait till publication of this list.
So, because I have already got the admit card. Before publication of the list, they treated me as untainted, and they gave me the admit card. So then, my lord, where is my cause of action? Very well, I was not working, but provision was made for appearance in the next exam, next recruitment process. I was allowed to participate in the next recruitment. Admit card is already given. But how will I know that a different list of untainted and tainted will now be segregation?
Approach the Supreme Court in an IA in a pending matter.
Well, kindly.
Since Supreme Court is in session of the matter, why court will consider?
Therefore, now comes the balance of convenience. Your lordship will see if the exam is on Sunday. So, my lord, if even after the exam, my fate can be decided. Even after the exam, my fate can be decided. My answer may not be considered or whatever. But today, if a firm decision is taken without there being active segregation of this distinction of tainted and untainted, then, my lord, my right will be lost forever. Yes. There is a question of balance of convenience. But here, my lord, that is why I just want to refer to 363. Why that is exhaustive? That is exhaustive because of the Supreme Court judgment. My lord, just the paragraphs which Mr. Lahiri has placed, my lord, that is extremely relevant. My lord, kindly just see once, my lord. Your lordship kindly sees paragraph.
Yes, that has been placed. I have seen.
No, I am not on that. I am saying.
That has been placed.
I am therefore saying that Supreme Court definitely came to the conclusion that first of all, there is destruction of original. Second, whatever copy is being produced, there is substantial cloud. If there was no substantial cloud, then...
So in your case, admit cards were issued, then thereafter you were enlisted as tainted.
My case also. Thereafter I have been enlisted as yes, admit card has been cancelled. Cancelled. Has been cancelled. That is what I have challenged here, Lord.
I have not shown the cancellation of the admit cards. I can show it in the cancellation screenshot.
Yes, any addition by anybody?
Item number.
I rest my thumb.
This candidate. This particular Malord teacher was Malord working, and her services were not terminated intact, but has been terminated pursuant to order of the Honorable Supreme Court. In that matter, Malord, an affidavit was filed by the
Supreme Court 3rd of April.
Yes, yes. Not working after 3rd of April. Now, page 62 is the affidavit which has been filed by the SSC before the single bench, which ultimately went to the Supreme Court. There, the SSC had said, but what the mismatch of marks, my lord, were there in respect of this particular candidate was to the tune of only 1 mark. The OMR sheet, if evaluated, would come to say 20. I have been given, would come to 19. I have been given 20. That is the only 1 mark. The SSC said in respect of this particular candidate kindly comes to, may I just place paragraph 63, page 63, first paragraph. Second paragraph. Secondly, in respect of
your that petition
of yes, item number 4. But this was never placed nowhere in the previous rounds of litigations. Those are matter on the points of principle.
Hey, page.
Only this. Now, my lord, page 63. This is the affidavit in respect of 910 candidates. Shubhamoy Bhuiya was the 910 candidate, one of the 910, my lord, writ petitions where it was been heard before the Honorable Justice, my lord, Vishwajit Basu. This affidavit was placed.
This is item number 4.
4, yes.
Page 63.
Page 62 is the affidavit. I will be placing from page 63 and 64. The order, by an order dated 6th February, the commission was directed, page 63, it is recorded, on 6/2/2000.
Affidavit by whom?
By the SSC.
Yes.
On 6/2/2023, in course of the hearing the instant writ petition, the court was pleased to direct learned advocate appearing on behalf of the commission to file a report in the form of affidavit to the modality to be adapted by the commission to exercise its powers under Rule 17 of the such and such.
Here no admit card was issued.
Yes.
Here no admit card was issued.
Yes, admit card issued, cancel. All matters. Admit card issued, cancel.
All matters.
All matters. Admit card, I can show one of the screenshots. I have not shown before, Lordship. I will show one of the screenshots. Here, that is February 2023. Why it was directed? Why you have not?
Which paragraph you are reading?
Paragraph 3. To give the background. Why this affidavit has been given. I'm sorry, madam. I'll just skip over I'll come to the relevant part. This is only to give the background. Since your Lordship is reading each and every paragraph. Rule 7.